Hello everyone, I am Barrister Mohammad Fariduddin and welcome to the Constitutional Law Lecture. In this video clip, I will discuss about the effects of breaching constitutional conventions. Hilary Barnett, a well-known writer on constitutional law, said that a non-legal rule which imposes an obligation on those bound by the convention, breach or violation of which will give rise to legitimate criticism. And that criticism will generally take the form of an accusation of unconstitutional conduct. Therefore, you should remember that unconstitutional conduct does not always mean unlawful conduct. Conventions are binding only insofar as the participants feel obliged to follow them. While some conventions seem likely never to be breached in modern Britain, such as the convention that the monarch will assent to a bill duly presented to her by the parliament, other conventions have been broken, and with different results. For example, collective ministerial responsibility is a convention that requires the inner circle of the government to speak with one collective voice publicly on policy, and for cabinet ministers not to disclose cabinet discussion. In 1975, the cabinet of the Labour government was deeply divided over whether or not to continue membership of the European Community. In that circumstance, the Prime Minister lifted the convention, allowing cabinet ministers to publicly advocate their differing views. Upon resolution of the issue, the convention was fully reinstated. No consequences followed from the breach. This illustrates the flexibility of conventions in contrast with the rigidity of laws. A totally different consequence of breach occurred when a convention broke down in 1908, when the House of Lords rejected a finance bill of the House of Commons. The then convention required the House of Lords ultimately to give way to the House of Commons, particularly on financial matters. But so far law is concerned, at that time the House of Lords enjoyed equal powers with the House of Commons. The response to the breach of the convention by the House of Lords was the enactment of the Parliament Act 1911, restricting the House of Lords to a power of delay, in effect placing the convention on a statutory basis. In conclusion, there is no hard and fast rule as to what ramification follows from the breach of a convention, and it varies upon the importance of the conventions, as we have already seen that in 1911 the consequence was to pass a statute, whereas during the Labour government the lifting of the constitutional conventions resulted no consequence at all. We may summarize that the characteristics of the conventions are that they are non-legal, that means the courts will not enforce them. Secondly, they are evolving. And thirdly, they are flexible. And fourthly, there is no set sanctions for breach. What is the position of conventions in a country with a written constitutions? This is not the case that conventions exist only in countries with unwritten constitutions. In fact, constitutional conventions exist in countries with written constitutions as well. Previously, the written or codified constitution of the United States has been shaped by conventions to some extent. For example, the fathers of the United States Constitution provided for indirect election of the president. But as a matter of convention, the president is now directly elected by the people. Again, the first president of the United States, George Washington, introduced a convention that a president should not continue for more than 2 terms. This was a convention only at that time. This convention was adhered to till 1940, when President Roosevelt offered himself for a 3rd term and even 4th in 1944. But such was the force of the convention set by Washington that the Constitution, that means the convention, was subsequently given a statutory effect by limiting the tenure of the president for 2 terms by amending the Constitution. Another example of the convention is that the 2 leading presidential candidates should engage in multiple televised debates with each other. The convention developed in the 1960 election when Richard Nixon and John F. Kennedy held the first nationally televised debate. So that is all for the convention, and in our next video clip I will discuss about some basic features of the Constitution of Bangladesh.